Hello everyone, my name is Vrinda Bhandarkar. I am a student of S.D.M Law College, and in this video we will be dealing with the concept of extortion. Do you remember watching these Bollywood movies where the villain takes away the hero and heroine's child and says that he will keep the child in wrongful confinement until and unless the hero and heroine sign all their property off to the villain? Is that an offense? If the police were to arrest that villain after everything comes out and everything is set out to be right, in that case, what offense would the police charge him under? That offense is what we are dealing with in today's video, and that offense is called extortion. Indian Penal Code extensively talks about extortion from sections 383 to 389 of IPC 1860. Now first let us understand what are the ingredients or the essentials that are required in order to constitute the offense of extortion. Firstly, a person is said to have committed extortion if he induces fear of injury in a person, either to himself or to another person. Now, mere words are not enough here. There is need to be an actual fear in order to overpower the voluntary will of a person. For example, in Miad's case, a clergyman was extorted by the accused by saying that he shall defame him by stating that the clergyman is a frequent visitor to house of ill fame. In this case, the extortion is that of defaming another person. The truth of the assertions made in case of defamation shall not be relevant while constituting the offense of extortion. There also lies a distinction between mere use of force and inducement of fear of injury. For example, in Lanka Hanumanta Rao versus State of Andhra Pradesh, the accused makes the complainant to sign 2 documents or promissory notes, and he takes away one of them. Based on the analysis of the circumstances surrounding this case, it came to light that there was no use of inducement of fear, but there was use of force upon the complainant in order to make the complainant sign the 2 documents for the accused. In this case, the offense of extortion will not be made out. Also, if the person on whom such fear of injury is being induced or on whom it is being affected, if that person does not resist or submits to the person who is extorting him, that also does not constitute the offense of extortion, as held in case of Duriluddin Sheikh, where the person was so paralyzed with fear that he refused to resist or he refused to act. He just stayed the way he was when he was being extorted. So here also there was no offense of extortion made out. Now let us understand the second element of extortion, that is dishonestly inducing the person so put in fear to deliver either some property or valuable security. In case of extortion, unlike as in case of theft, both movable as well as immovable property form the subject matter of extortion. When we break down the second element, the first element would be dishonestly. Dishonestly forms the element of mens rea or mental intention in this case. Here, there requires to be a coexistence of both wrongful gain as well as wrongful loss in order to form the mens rea required for the commission of this offense. Now there should be a delivery, that is the person must voluntarily deliver either a property or a valuable security. Valuable security has also been defined under Indian Penal Code under section 30 of Indian Penal Code. Furthermore, now let us understand that when there is no legal duty that is conferred upon a person or which is already upon a person that he must perform a particular duty, and if he omits to do it, then it might form an extortion. But if there is no such legal duty present or incumbent on that particular person, then making demands based on that cannot form an element of extortion. For this particular point, let's understand a case, that is R.S. Naik versus A.R. Antule, wherein demands were made to sugar operatives to provide certain donations in order to keep their cases or their particular issues first for consideration. Here, as there was no legal duty in question, it would not constitute the offence of extortion. Now let us understand what is the punishment in case a person commits the offence of extortion. Under section 384 of Indian Penal Code, whoever commits extortion is punishable with an imprisonment extending to 3 years or with fine or with both. Under section 385 of Indian Penal Code, whoever commits extortion by putting any person in the fear of injury while committing such extortion shall be liable to undergo imprisonment extending to the period of 2 years or with fine or with both. Now let us deal with certain aggravated forms of extortion, that is extortion of a more serious nature. Under section 386 of Indian Penal Code, putting a person in the fear of death or grievous hurt while committing extortion has been dealt with, and such person is punishable with an imprisonment of 10 years and shall also be made liable to pay fine. Under section 387 of IPC, putting a person in fear of death or grievous hurt in order to commit extortion has been dealt with, and such person is liable to undergo imprisonment of 7 years and shall also be made liable to pay fines. Under section 388 of Indian Penal Code, whoever commits extortion by accusing a person of having committed an offence which is punishable either with death sentence or life imprisonment shall be liable to undergo an imprisonment of 10 years and shall also be made liable to pay fines. Under section 389 of Indian Penal Code, if a person extorts another by accusing him of having committed any offence, he shall be liable to undergo imprisonment of 10 years or he can also be made liable to pay fines. However, if the offence that he is accusing another in order to extort him is of nature that falls within section 377, that is unnatural offences, in that case such person shall be made to undergo life imprisonment. Now that we have covered all the aggravated forms of extortion as well as ingredients of extortion, now let us understand what are the primary differences between extortion and theft. Extortion may have either movable or immovable property. That is, both movable as well as immovable property can have been a subject of extortion. However, in case of theft, only movable property can form the subject matter of theft. The second difference would be that in case of extortion, the extorter or the accused wants to overpower the will of the complainant in that particular case, and therefore he does not seek consent, he wants to overpower the consent of such person. But in case of theft, the person who is trying to commit theft does not take the consent of the complainant in that case, or the person who has his goods stolen. The thief does not take consent. But in case of extortion, the person overpowers the will of the person who is being extorted. The third difference between extortion and theft would be that in case of extortion, there is an element of force that is present, but in case of theft, there is absence of the element of force. The fourth and the final element of difference between extortion and theft would be that in extortion there is delivery of property by the complainant to the accused, which forms the essence of extortion. But in case of theft, there is no delivery of property, there is taking away of property dishonestly. Also, another difference, if we analyze both the ingredients of extortion as well as theft, would be that in case of extortion, when the mens rea element, that is dishonest intention, is considered, both wrongful gain as well as wrongful loss must exist. But in case of theft, either of wrongful gain and wrongful loss may be present, even then it would constitute the offence of theft. Thank you very much for watching this video. Happy learning.